Good morning, Mr. Ford.
Good morning, Chief Justice.
How are you?
Good morning, Commissioners. I'm well, thank you for asking.
Good. May we start? Do you give me permission to start the interview?
Absolutely.
Okay. All right. You are an advocate.
I am.
Since 2011.
That's correct.
Where do you practice?
At the moment, I practice with a group called Oxford Chambers. We're based in Ilovo, Sandton. Oxford Chambers is one of the groups that's affiliated to the newly established South African Bar Association, also operating from Ilovo, but which has now started a national footprint with a group in Cape Town and a group in Johannesburg.
All right. But you wear many other caps in addition to being an advocate. You were a commissioner of the CCMA, not any longer, as I understand it. Or do you still do that work on a part-time basis?
Not at all, Chief Justice. I ceased being a commissioner after coming to the bar in 2012, 2013. So thereafter, I continued doing work at times in an ADR capacity, but no longer as a commissioner of the CCMA. All
right. How long did you practice work as a CCMA commissioner, or all combined?
All together, as a CCMA commissioner, it would be from 1998. Then there was a short break in service brought on by the death of my brother, and I spoke to the then Tandi Olaine. She was the director at the CCMA and allowed me a sabbatical of, I think, 3 months or so, in order for me to just recuperate emotionally and then to continue thereafter. So I would say all in all, with the CCMA and the other ADR institutions such as bargaining councils and the like, I would think it's just on 13 years, 12 to 13 years, if I add all the periods up collectively, Chief Justice.
By the other things, you mean your role as an arbitrator, an IMSA arbitrator, and what else? There's quite a lot of these other things you do.
Yes.
All right. You hold a BA and higher diploma in education from UWC.
That's correct.
And actually started out as a teacher.
Chief Justice, I'm a bit challenged because you're so far away from me.
You can't hear me?
I'm struggling a bit.
Oh, sorry about that. Can you hear me now?
I can hear you a little better.
Just a little. I've been accused of having a sharp voice. I'm disappointed with myself. You started out as a teacher.
That is absolutely correct.
Following your BA and higher diploma in education qualifications.
That is correct.
All right. And you were once a music teacher.
So what happened was I grew up in the New Apostolic Church. And it's a church that's primarily focused, amongst other things, on music and music development. So I was fortunate growing up in that environment to be exposed to music from a young age. So I would play organ in the church, I still play the piano, and at times I've been invited to play at funerals and at weddings. Sadly, the weddings that I've played at, somehow the marriages disintegrated. I'm not sure whether that has anything to do with the nature of the music that I provided. But anyway, so that's where the love for music came in. And at the school where I was, I would teach music more as one of the elective type segments. But then later, when I joined the New Apostolic Church Administration Officer, I held a position, what is called a music coordinator, myself and a very close friend of mine, Jimmy Bourne. And that role was primarily a music teaching and choir conducting role, which obviously resulted in me being a lot more involved in teaching of young musicians. Music is still part of a very a passion in my life and something that I explore as part of a hobby that will probably never die.
All right. Well, you then changed direction. You studied for a BA honors in labor relations and human resources management at Rao, and then an LLB with UNISA.
That is correct.
All right, and you left your first love of teaching music.
Yes.
What kind of work do you do? I see in your questionnaire that you've listed labor law and administrative law work, only 5% for administrative law and the rest for labor law.
Yes. So, Chief Justice, I do a lot of labor-related work. So I appear in the labor court quite often. The last I checked, it was at least once a week, at times a little more than that. I get invited to chair disciplinary hearings by various both public and private sector organizations. I get involved in fact-finding investigations. I represent employees who have been dismissed. So it's a very varied spectrum of labor-related services that I provide in that respect. And I have done, to a limited extent, a little bit of administrative law-related matters. But I think the bulk of my practice would be labor, civil litigation, and admin law. And then a big passion for me is the question of land, and perhaps what I believe to be the slow pace of land reform. In fact, just last week, I was fortunate enough to speak at a conference at UNISA on this question of land. And part of the panel at that conference was the likes of the former DCJ, Moseneki, and various others. And my segment specifically had to do with the fact that the indigenous people in our country are still landless. So, in a nutshell, Chief Justice, that's what occupies my time. And a lot of the work that I do on a pro bono basis. In fact, if I were to attribute a percentage of the work that I do on a pro bono basis, as somebody once said, I will never get rich. And that's probably absolutely true, because I do a lot of pro bono work. I would say up to 40% of my practice would be doing pro bono work.
You've acted at the labor courts since 2022, well, for 2 years, between 2022 and 2024?
That's correct.
Was that for that entire period or just stints?
No, in fact, it was 4 weeks in 2022, 2022-23, and then in 2024. I indicated incorrectly so in the questionnaire that I acted for 4 weeks, but it was in fact 5 weeks. And that period was split between Cape Town and Johannesburg.
How long in all?
All in all, it would be 9 weeks, both Cape Town and Johannesburg.
Did you get to write judgments during that time?
I did.
How many?
Altogether, I've counted, I think it's 29 judgments. And together with the judgments for the period that I acted in the High Court acting was 22 weeks or thereabouts.
Yes.
39 judgments in the High Court. So just under 60 judgments over the last 2 years.
When did you act in the High Court?
In the High Court, I acted in Johannesburg as well as in Pretoria.
When?
in 2022, 2023, as well as 2024.
All right. So you were hopping between the Labour Court and the High Court?
Indeed.
Okay. When was your last acting stint?
My last acting stint in the Labour Court?
No, anywhere. In any court?
It would have been towards the end of last year. I think in October, JP Lambo had called me and asked if I can please assist. I think it was for a week or two. And I then went through and I assisted in the High Court in Pretoria.
All right. You listed 6 reserved judgments from the High Court when you submitted your questionnaire. Have those judgments been delivered?
All of them have been delivered.
All right. You also indicated that you had parted matters as well.
Yeah.
Or was it just one?
No, there's one particular part-heard matter. In fact, I'm not sure it's fortuitous, but that matter is proceeding tomorrow in the High Court in Johannesburg.
So there is progress there.
Yeah, perhaps let me just qualify why that has happened. The registrar that was assigned to me had tried, unsuccessfully so, to set the matter down on previous occasion, and each time that he set it down, one or both of the counsel would be unavailable. I then escalated the matter to DJP Sutherland, and he asked me to set a final date for that trial, or the continuation of that part-heard trial, and it continues tomorrow until Friday.
All right. Are any of your about 60 judgments reported?
Yes. In the High Court, I speak under correction. I think there's 2 one specifically. And in the Labour Court, the Lesedi judgment. Now, ordinarily, for instance, in the Labour Court, what I would do when I've done my judgment, I would consult with the senior judges in the Labour Court, like then Judge Van Niekerk, as well as Judge Mushwana, and share the judgment with them and ask them to guide me in terms of whether or not for them trying to amend what my conclusions are, the legal conclusions are, but to see whether, insofar as form and structure, the judgment was sound. And after such an occasion, when both of them had indicated that they believe the judgment is sound, I then noted the judgment as not reportable, if I remember correctly. But when the judgment was eventually released, it was then reported. I speak under correction insofar as the process that was followed in how the judgment eventually became reportable. And then the same happened with Olofsson versus Ngobo in the Johannesburg High Court.
Any of your judgments taken on appeal?
Yes.
And what was the result?
In the, I've attached the West Bank matter, the West Bank versus Maseko. That judgment was taken on appeal, and the appeal court had found that, in essence, perhaps if I can just give a bit of context in that particular matter and why the appeal court felt
briefly,
that...
please. Very briefly.
Very briefly. Well, Mr. Maseko had approached a financing institution to ask for a loan. When he had done so and filled out all the forms, he was then informed that he will be advised that his loan would be approved, and in doing so, he needed to supply certain forms of security, like his banking statements, etc., a number of other things. Pursuant thereto, he then discovers that he actually sold his vehicle, and that he sold his vehicle and simultaneously bought his vehicle back for double the price. That then took me by surprise, and the evidence simply suggested that there was somehow a a simulated transaction. The full court felt that I had strayed because I ought to have confined myself only to the fact that there was, in fact, a contract that was concluded, and I ought not to have considered anything wider than what actually transpired, and then set that decision aside.
All right. Okay, you have disclosed a medical condition. Is it under control?
It is under control.
Does not interfere with the execution of your duties as a judge? Well,
it would not interfere.
As an advocate, rather. All right. Okay, thank you very much, Advocate Ford. Judge President Mugahle, do you have questions for the candidate?
Thank you, Chief Justice. Good morning, Mr. Ford.
Good morning, JP.
Just let's pick up on the last point which was raised about the appeal, but there is another appeal matter. I think it's NMC versus RAF.
Yes.
And the judge who penned the first judgment you referred to is the same judge. I think it's Judge Dlamini.
Dlamini, yes.
Sitting with Judge Fisher and Judge, I can't recall the others, but they commended you in the approach you adopted in dealing with the issue of expert witness in as far as that matter is concerned. Is that correct?
Yes, that is in fact, and thank you so much for reminding me, JP, that was a road accident fund matter. And the view that I took there was that an expert, you know, the old adage that says the person who pays the piper calls the tune, ought not to apply in circumstances when an expert witness is called to testify. So yeah, I had forgotten about that particular judgment.
Thanks for that. But I see that when you got admitted, you started off doing mainly RAF. What informed the shift from RAF to Labour?
Yeah, JP, it's a strange situation, I think, that referral advocates find themselves in, because as referral advocates, we are exposed to the briefs that we are allocated. And I suppose the first time I was given an RAF brief, it was a bit challenging for me because my background had been Labour, and my first love had been Labour and still is. So it came as some difficulty for me to make that shift from Labour to the road accident fund related work. It also caused me to read up on road accident fund related material, the acts, the regulations, and that is how I then started getting involved in road accident fund litigation.
Okay. And I see you just said that you appears in the Labour Court at least once a week.
Yes.
That seems to be quite a significant period spent in the Labour Court.
Yeah. As I say, JP, my practice is largely Labour Court driven, both in respect of trials, the occasional unopposed motion, the opposed motions, and on average, that's not to say that, for instance, this week I was in the Labour Court. I wasn't, but last week I was in the Labour Court. Yes.
Okay. And I see also that your main time is now spent in the CCMA representing parties in the arbitration hearings.
Yeah. I generally only, or mostly, not only, represent employees in CCMA proceedings. I remember one of the attendees at the conference last week says that it is so sad to see that justice and access to justice is becoming a commodity that can only be afforded by the very wealthy or those who litigate using state resources. So I generally mostly appear for employees in the CCMA.
Okay. Now, just correct me if I'm wrong here. My notes I indicate that you said that there are no reported judgments in matters that you were involved in.
Yeah, not
I'm
that
trying to contrast that with appearing in the labor court all regularly.
Yeah, I couldn't find the reported judgments, JP. The judgments are well published on SAFLI, but they're not the status of a reported judgment. So in most of the matters that I've appeared are in fact
They would appear on SAFLI.
on SAFLI,
Okay.
but not in the traditional law reports. So certainly not unless somebody points it out to me. Yeah.
Okay. And you indicated that you have one outstanding part head in the High Court.
In the High Court.
You have no part head in the Labour Court.
I've got no parties in the Labour Court now.
And reserved judgments in the Labour Court more particularly.
I've got no judgments outstanding in the Labour Court. JP, you would recall the only one issue that happened is that sad situation, Le Franschhoek.
Yes.
And that I fully explained what transpired there in as far as what caused the delay in the issuing of that particular judgment. But all judgments in the Labour Court have been finalized and delivered.
Yes, quite understandable, and I guess we can disclose that it has to do with the way the judgment was emailed.
Correct, yes.
And you thought it had gone through when it was lying in your outbox.
Exactly.
But let me ask you this question, because the policy at the Labour Court now is that every time you write a judgment, soon thereafter, the secretary will start sending you emails to remind you. You did not receive those emails.
I did not receive any email. In fact, when I did receive the email, and that was what triggered my response, because I knew the judgment was completed in fact, shortly after leaving Cape Town, I completed the judgment. So I was quite stunned and surprised when I saw that email, and immediately thereafter, literally within a day, if not the same day, I sent through the judgment.
Yes. And what's your attitude towards secretaries sending you reminders? Because arising from your case, I called the secretaries and I said, what's going on? We agreed that you will remind your judges of this. Now, one told me quite specifically that one judge, when he said, Judge, according to the policy, I'll be sending you a reminder, an acting judge, he said, I don't want to be disturbed. What's your attitude towards it? I see you laughing.
I think it is, firstly for me, it is welcoming to be reminded, because I will never be so arrogant, and I hope nobody is so arrogant to say that you remember all things, because we are human beings, we forget things.
Yes. And I see there's one complaint against you, which has gone before the first stage of the committee, and the committee dismissed it. It's now before the appeal. And as I understand, that complaint relates to you refusing to overrule Judge Mushwana in a ruling where he directed that the matter be referred back to the CCMA for transcribing the record.
Yeah, JP, I'm not so sure, because I think day before yesterday, or was it not towards the end of last week, I did receive communication from the JCC informing me that the complaint has been dismissed in its entirety. I then contacted the Secretariat and asked them please to ensure, if it's possible, that that complaint and the outcome of the ruling of the JCC be circulated. Yeah.
Thank you. And tell me...
Chief Justice, if I could help the candidate and Judge Mulahlei, it was circulated, and the Objections Committee also commented on it. You've been totally cleared.
Thank you, Commissioner.
Oh yeah, sorry I missed that. I just got distracted for a second here. He's absolutely right. And I must declare as well that I was once involved in that complaint. Not that it matters.
Thank you very much. Now, let's come back to the acting. I see you acted for about 8 weeks in the Labour Court. There's a total period you've acted.
In fact, it's 9 weeks when I calculated
Oh, yeah,
the
you
last
said
stint.
that it was 9 weeks.
Yes.
You didn't act before 2023, because I tried to look at the records and it was difficult for me to see if you had, in the previous years, acted at the Labour Court.
I did not.
You did not.
I have, though, made myself available for acting. I did communicate with your predecessor, but I didn't get any responses there too. It was only from 2023 that I then got responses to act. I was always able and available to act in the Labour Court.
Okay. I guess that problem, now it's been addressed through the ensuring that the acting is done by a committee, and that preferably you need to be recommended by the law bodies. So there's a process that needs to be done now,
yes,
rather than speaking directly to the JP.
Yes.
Okay. But now, in the period that you've acted, have you done urgent court?
I have.
And you did it on Court Online. I guess you would be familiar with Court Online from the High Court.
From the High Court, we've been using Court Online, but when I did the urgent role, we didn't do it in Court Online. It was still manual.
Okay. So that was before the
transition, yes.
And tell me, have you seen the latest directive that's coming through into effect on the 14th of April relating to the implementation of the Court Online system, and what's your view in terms of its implementation?
It's to be welcomed, JP. I think it's a move in the correct direction. For me, given the nature and the scope of the Labour Court, what's always a concern is how we accommodate the unrepresented, the indigent and the poor, in making sure that they are not left out in the digitization that we're pursuing. But insofar as making it as a judge, it's such a useful tool to have all your documents centrally aligned, accessible. It is really a move in the right direction, and it's certainly something that I would encourage.
Okay.
And compliment you, by the way.
And have you done any matter on the virtual court?
Yes, I have.
Okay, so you are familiar,
I'm familiar
with the court.
With it.
Okay. And you acted for 22 weeks, from my calculation, in the High Court, 8 weeks in the Labour Court.
Yes.
In that period, have you done an unopposed motion, particularly in the Labour Court? Because the unopposed motion in the Labour Court is slightly different from the High Court.
Yes. So the unopposed motions in the Labour Court is a bit of a mixed bag, as opposed in the High Court, you deal with a lot of insolvency-related matters, bank matters, summary judgment applications. Whereas I found that the unopposed motion court, because in the Labour Court you don't have like what we have in the High Court with your special interlocutory court, so everything is then, to the extent that it's unopposed, will form part of your unopposed role. I think the unopposed role in the Labour Court, given the fact that the matters are so diverse, I found a bit more challenging at times than the unopposed role in the High Court.
Okay. Thank you. And I see you traveled only once to Cape Town.
To Cape Town, yes.
You are aware that the Labour Court does judges travel around the country. You have no problem with that?
Not at all.
Because it's likely to increase now that we are extending the footprints in the other provinces. So you wouldn't have any difficulties with that?
None whatsoever.
Thank you, Chief Justice.
Thank you, JP. Do the colleagues from NETLEC have questions for the candidate? No? All right. Commissioner Marumachai?
Thank you very much, CJ. Good morning, Advocate Ford. I'm here.
Oh, good morning, Commissioner.
I was quite pleased to hear that you are doing quite a lot of pro bono matters, which is quite important, really, in the labor space. because of the fees that are involved and the difficulty in going through the various forums before you can even get to the labor code. There is one issue that is likely to be experienced by those kinds of clients who don't have the financial means to take matters to any of the tribunals before you go to the labor code. And this goes into the breach of trust when you are dealing with issues of dismissal. I'm not sure if you are aware of the Labor Appeal Court case that dealt with how you have to negotiate the issue of breach of trust and whether or not it can be a ground upon which dismissal can be found. I just want to ask you this question, whether or not you are familiar with that decision, because it was quite interesting as to how they dealt with the concept of intolerable in the context of what I'm talking to you about. Can breach of trust in the employment context be a ground upon which a dismissal can be found? If yes, under what circumstances?
Yeah, I suppose I think trust is a vital, if not a indispensable part of the employment relationship. But that trust should be a mutual trust between the employer and the employee and vice versa. The Code of Good Practice in the Labour Relations Act had indicated that where in circumstances the employee commits an offence, and that offence renders the trust relationship severed, that in such circumstances you would be able to terminate or dispense with the employment relationship. Now, what I often see is that, and I'm talking from my experience practicing in this field, is that any complaint against an employee is somehow placed under this umbrella of you've committed X and therefore you've breached the trust relationship. The trust relationship must go to the heart of the instances where you would have been required as an employee to act in a manner that is honest and upright in your dealings with your employer. But you can't have a timekeeping problem and have the timekeeping problem be equated to a breach of trust. I'm not sure whether you follow what I'm saying in that regard, Commissioner.
I do.
Yes.
No, thank you very much, Judge Ford. Thank you very much, CJ.
Thank you, Professor. Any more questions, colleagues? Chairperson?
Thank you very much, CJ. Good afternoon, Advocate Ford.
Good afternoon, Commissioner.
Now, the South Africa's labor market is evolving with challenges like automation, your remote work, and the gig economy. How should the labor court adapt to ensure its jurisprudence remains relevant in addressing the modern employment disputes? That's the question.
Yeah. So, yes, I think automation, digitization, all of that have become a reality, and it's a reality that's going to be with us, and none of us can escape it. The Labour Court, and I remember when I listened to Justice Savage when she sat in the seat that I'm sitting now, explained how important an institution the Labour Court is. It's an it's important for our economy, it's important for our labor market, it's important for socio-economic and political stability. And the Labour Court has acquitted itself extremely well in adapting and dealing with automation, in dealing with various types of employment scenarios. And you have a very skilled team of of competent judges that have acquitted themselves exceptionally well in dealing with this. And I think the Labour Court is by virtue of some of the initiatives that the JP has introduced, and such as Court Online and the like, on the right footing, and it should ordinarily be that a Labour Court should act consistent with the manner in which we acted previously and consistent with the LRA and the Constitution, and I submit in that regard the Labour Court is well on track.
Thank you very much for the response. The initiatives that you spoke about, are they being adequately resourced?
Yeah, I think I can speak from both the practitioner's point of view and from a acting judge point of view. As a practitioner, we are happy when we see some of the initiatives that the Labour Court under the leadership of the JP has introduced. And because I used to work with Judge Molashedi at the CCMA many years ago, it's the same sort of trajectory that I experienced when I worked with him at the CCMA is what I see in the Labour Court. There's continuous engagement, continuous information sharing, continuous outreach to practitioners for ideas, commentary, etc. So I would think from a practitioner's view, in terms of what is being laid out, is consistent with ensuring that the Labour Court acts in a resourced capacity. Now, as an acting judge, and I think one of my biggest concerns, and it may very well be a concern that the JP has addressed, is the unrepresented. So whenever I sit in the Labour Court, I will firstly ask the parties who are represented to deal with their matters first. And then when the unrepresented are left in the room, I have done it and I've seen many, many other acting judges and judges do it. They would then take their time, and often the court staff who work with them would use their time and place themselves at the disposal of the judge, sometimes working into their lunch breaks to ensure that assistance is given to the unrepresented, in order to ensure that this ethos of the Labour Court being a court of equity is not even only spoken about, but it can be practiced in reality. I hope that answers your question, Commissioner.
No, thank you very much, Advocate. My next question is with regards
just a reminder, Commissioner Tsipane and other commissioners, it's 2 questions per commissioner. And in the rare event, a follow-up question may, at my discretion, be allowed.
The second one was a follow-up question.
Was
From
it?
what you said, yes.
Or maybe I got confused by the long answer from the candidate.
Oh, yes.
Okay, put your question and you try to
thank
keep
you
him
so
short.
much. All right.
Good.
Now, my next question is with regards to delays in resolving the employment disputes, which can, in my view, can have severe impact on the financial and emotional finances of the employers and the employees. Now, what practical steps would you take to improve the case management and the efficiency in the Labour Court?
Now, I remember during the last stint, I had a discussion with the JP in his office, and he pointed to some files in the corner of his chambers, and he was working through them systematically. And I then indicated to him when I saw what he was doing to say that there must be a way in which the judges or the acting judges can assist in that process. And the obvious, and I think it's a valid concern expressed to me, was we're short of judges, and we don't have the luxury, and that's why he, as the JP, and I was quite humbled by that, was working through those files. So I think, firstly, the appointment of additional judges would help with the backlog in the Labour Court. But in terms of what one can do to ensure that labour disputes are expedited, I think, and if I may express an opinion here, Chief Justice, I think for me personally, you have a situation where you have a dual referral system of disputes, which causes serious and unnecessary delays for poor employees. Let me explain it. An employee is dismissed. He then fills in what is called a 711 referral. And within 30 days, the CCMA places that matter on its roll for conciliation, subject to allowing the parties to object to CONARB. In CONARB, it simply means if no objection is filed, the matter will then proceed to arbitration. The employers invariably object to CONARB for no reason, simply objecting, no qualification. Now that poor employee must now fill in another form and wait for another date for arbitration. Now, had it been that one process was set down, then whether you object or not would not mean that the process comes to an end, and have that poor employee having to fill in further forms in order to get the matter resolved. And those are some of the difficulties that I think from a practical point of view might help in reducing the time limit. The other factor, Commissioner, is this. I assisted an employee who was dismissed in 2019. It's 2025. That matter is still not resolved. Everything that we've done, every step of the way, there's been challenges, it's now going to the Constitutional Court. And it goes directly against the objects and purports of the Labour Relations Act.
No, thank you very much, Advocate, and thanks, CJ.
Good afternoon, Advocate Ford.
Good afternoon, Commissioner.
Yes. I have a question for you arising out of the Lesedi local municipality versus Mpele.
Yes.
The one that dealt with embellishment of the qualifications.
Yes.
I got a sense that you were sitting as a reviewing judge, reviewing an award coming from the CCMA, where the commissioner had actually found that the dismissal was substantively unfair. And the municipality then reviewed that award. Now, the basis for your order was that the commissioner had misconceived the inquiry in the sense that he did not assess the evidence correctly. Now, my question to you is, does an assessment of an evidence go to the actual decision making in the sense that is it an error of law or a reviewable irregularity?
Yeah, so Commissioner, so we guided by which I can say the two pillars when we deal with labour reviews. The one is Sudumo. We simply asked the question whether the decision that was made by the commissioners one a reasonable decision maker could not reach. Then since Sudumo came Harold versus Nedbank, and in that decision the SCA simply said that what must be demonstrated is whether or not the commissioner or the arbitrator misconceived the nature of the inquiry and thus arrived at an unreasonable result. So, when unpacking the Lesedi decision is to unpack that misconception of the inquiry simply further. Meaning, if one steps back and asks yourself, what would a reasonable commissioner do? And then answer the question by saying, what is typically required in an inquiry? And what would then constitute a misconception of that inquiry? And what I then laid out in Lesedi is, when arbitrating a dispute, you would follow a particular process. And you would then follow another process in arriving at a decision. The one process is the process that is formalized in allowing you to run the arbitration proceedings, such as calling witnesses, etc., etc. The other procedures is that which happens in the mind of the decision maker. I think the decision, if I remember correctly, by I think it's Justice Wallace, who said, you then deal with what we called latent irregularities versus dialectical irregularities that points in the direction of what happened in the mind of the decision maker. Now, when I considered the totality of the evidence that was presented, and the totality of evidence presented was that this particular individual held himself out to have these qualifications, and he does not have them. From that sense, if that was the evidence, then you look at what the evidence was and what is the eventual outcome. And if the eventual outcome competes with the evidence, then an inference can be drawn that the decision maker misconstrued the nature of the inquiry, and that gave rise to an unreasonable result. So, in that regards, my conclusion was that the decision maker had misconstrued the nature of the inquiry when one considers the evidence that was presented and look at the outcome that was eventually arrived at.
Thanks for the answer. But we know that litigants should not actually conflate review and appeal. And as far as I can recall, labor courts deprecate litigants who appeal under the guise of or review and or appeal their awards under the guise of review. And when I read your judgment, I got an impression that I got an impression that the municipality had actually disguised itself in review when they were actually appealing the decision, because failure to assess an evidence, it's an error of law, isn't it?
No, absolutely. The failure to assess the evidence could be an error of law, but it could also point to a misdirection, and that misdirection, and the important qualification, Commissioner, is this. When you look at the eventual outcome, and you contrast that with the evidence that was presented, and it may not even be that the outcome is correct, and that is not what under a review court is concerned with, whether the outcome is correct. The outcome is the outcome a reasonable outcome? Now, when you have a situation where somebody claims, I've got all these qualifications, and the evidence that was presented before the Commissioner points to the fact that he does not have that qualification or the professional qualifications he claims to have. And for the Commissioner then to make the transition from there and say, look, I still find that this dismissal was unfair. For me, having considered the evidence, was a bridge too far to cross. And I submit under those circumstances, I concluded that the Commissioner had misconstrued the nature of the inquiry, which gave rise to an irregular result.
Thank you, Chief Justice.
Commissioner Balwe?
Thank you, Chief Justice. Good afternoon, Mr. Ford.
Yes.
Yes. Mr. Ford, you have given us three, one judgment and 2 awards, in fact.
Correct.
Now, you would know that part of what we do in assessing candidates is to look at the work that they have produced, and then that's part of the assessment, tools that we use. Now, the one award is a 2002 award. I don't see that it is helpful in any way, and I'm prepared to accept that since 2002 you have evolved, as we all do, and we've grown in the way we do things. And then you've got the next one in 2011. The 2002 one is a straightforward dismissal dispute for fraud, and the 2011 is there was a debate about the admission of evidence that was unlawfully obtained, right? And then you've got the Mpele one, Lesedi, that you've just discussed now with Commissioner Mangena. Now, the Lesedi one is about dishonesty, inflation of qualifications. It's not clear to me, it's not obvious to me why and how you would have selected these 2 awards and the judgment to convey what to us. Firstly, because it's not obvious to me, because they involve issues, everyday issues. There's nothing in particular that I thought is new and complex in these. I've already said to you the 221 might just as well discount it, because that's in your early days, and I'm sure it's not reflective of how you write today. So the question is, what informed how you selected these? Why have you not given us more recent judgments? Because I see you were in the Labour Court and you've listed about 24 matters. Why it is that you've not given us any of that work?
Yeah. So, Commissioner, let me start by answering your last question first. The matters that I considered reportable in the Labour Court, you may note on the schedule that forms part of the papers that I've indicated those are in fact reportable, but they have not actually been reported. Now, I accept full well that the arbitration award, in fact, the 2002 award, I think it was when IMSA had disintegrated, John Brand then somehow got some of us involved to start AMSA and had indicated that AMSA awards would become, to the extent that they meet certain criteria, become reported. And the issue there had to do with, and it may sound like it's a normal run-of-the-mill case, but it had to do with the question of attempted fraud. And when you read that award, I then go into depth to dealing with the concept of there can't really be a legal concept such as attempted fraud in circumstances where the person acted effectively alone. So the idea was to share with you a decision that was reported, and that decision is by no means a judgment, but it is a reported decision. Similarly, with the 2011 decision, and what I wanted to demonstrate there was that it had to do with the question of unconstitutionally obtained evidence and whether or not that somehow affects how that evidence ought to be treated within the context of Section 138.10 of the LRA. And that was really the context within which it was presented. And then the Lesedi judgment. The other reported judgments are judgments in the High Court. The Ngobo versus Ulof's decision that has to deal with when and how an interim payment can be made on a second occasion. I submit I can't take it any further than that, Commissioner.
I guess what I'm raising with you is that on what you have provided us, it is very difficult, at least for me, to conduct a proper assessment of your written work. I mean, you speak of reported judgments, but in fact, in the Labour Court, you've indicated about 3-4 judgments as reported or reportable, written judgments, in fact.
Yes.
And only one of them has been provided to us. I'm more interested in your recent work, not your 2002 work.
No, and that comment is as well accepted, Commissioner.
Thank you.
Safe to say that those judgments are in fact available. They may not necessarily be reported, but they are published on SAFLI.
Thank you, Mr. Ford.
Can I make a follow-up?
Commissioner Mngqetho?
Yes, thank you, Chief Justice. I mean, why then did you not submit what is required? I don't understand what you're saying to Commissioner Baloyi. I mean, what are we going to do with an arbitration award when we are trying to appoint a judge?
No, I accept that critique is fairly made. And
I know you've already said that to Commissioner Baloyi. I want to know why you submitted it.
Commissioner, I thought I'd explained why I've submitted it. Do I accept, in hindsight, that particular award and David's decision does not assist this committee? To the extent that I presented those simply to demonstrate the nature of the issues that I've dealt with in that arbitration award. But I'm by no means saying that they are judgments. So in essence, for purposes of determining whether or not they are judgments that would assist the JSC, I would say the JSC may very well disregard those two decisions, but that the decisions as indicated in the schedule, which I've marked reportable, which may not necessarily be reported, that those decisions are in fact available, and if possible, the Secretariat, or I can make that available to the Secretariat to make it available to the Commissioners.
You see, that's the problem I'm finding, Advocate Ford, is that the application form tells you what you should do, give us judgments. You then decide, well, I'll give you arbitration awards. When Commissioner Baloyi is asking you about these awards, you say, well, disregard them. Then you say, no. The form says, give me reported judgments. You don't give us reported judgments. You give us report-able judgments. And then when I ask you about that, you say, well, I can collect them and give them to you. So it seems it's a bit chaotic, the manner in which you are dealing with your application. And it's making me unsettled. So maybe you can help me to relax my mind.
So, Commissioner, let me assist in this way by simply stating that one award was attached, in fact, two awards, one dating back to 2002, the other to 2011. The reported judgment is the judgment of Lesedi. The judgments that are noted in the schedule are simply reportable judgments. So in essence, it will only be one reported judgment and the others are reportable.
Well, that should have been the answer, isn't it? Just give us the one judgment and then don't try to embellish it with other things.
Minister?
No, just to follow up and take the matter further from Commissioner Mngqetho. I noticed that in your response in the questionnaire, you either opted to use one word or just give a short answer that didn't give detail to issues, and I can go on. I mean, just even on the issues around articles that would have been written, what proportion of your litigation work has been, no explanation, you just gave the percentage. Can you just explain in terms of how you handled this process of application? Because either Advocate Ford, you didn't have time, no, you didn't take this process serious enough to dedicate time to give us what is needed for us to be able to make a decision. And that's what it goes to, how you would have made a judgment of putting what is required by the questionnaire versus what you are now explaining in this commission.
Commissioner, the explanation that I gave does not seem to undermine the proceedings or the fact, confirm or point to the fact that I did not have time. The questionnaire, as presented, is not embellished. It's simply responding to the questions. In hindsight, the only judgment that should have been reflected there would have been the Lesedi decision, because that is the reported judgment. The other two are the reported arbitration awards. When the questions are set out in the questionnaire insofar as whether any of the articles or articles that I've written, were they ever published, or I've answered those questions, whereas the answer might be straightforward, the answer is true.
Commissioner Pillay.
Thank you, Chief Justice. Good afternoon, Advocate Ford.
Good afternoon.
May I ask you about your Civil Aviation Authority judgment?
Yes.
That you handed down in, I think, in February this year. And it seems to be that the judgment was handed down in the context of a leave to appeal.
Yes.
And you took the opportunity then to vary your order in relation to one of the grounds of leave. That's correct?
Yes.
What I find interesting is that in doing that, Advocate Ford, you don't reference what method you use to vary your judgment. In other words, which rule you were applying or how you were applying that rule. What you do is that in response to the leave to appeal, you then vary your judgment, and then you point out that the parties may want to reconsider the basis on which they appeal your judgment because of the changes you effect.
Yeah. Thanks for the question, Commissioner. Perhaps a short explanation. The Civil Aviation sought to review and set aside a decision, both in respect of substance and fairness. During the course of that presentation of the argument, I then pointed out that the Civil Aviation Authority seems not to be challenging the Commissioner's conclusions around his findings on procedure. And it was then confirmed that, in fact, they do not challenge the Commissioner, apart from, I think there was one note somewhere in the statement to say that, but it was it was almost a nebulous reference. It wasn't a specific reviewable ground. I found that the case presented by the Civil Aviation Authority was sound, and that I concluded that the Commissioner had committed a reviewable irregularity insofar as the substance of the dismissal is concerned. But that I found that since the Commissioner's decision insofar as procedure is not challenged, that what ought to follow is that part of the Commissioner's ruling will stand. What then follows was a calculation error in terms of 12 months vis-a-vis the amount set out in the arbitration award. So when the variation was then done, was simply to say that the order, insofar as the variation is simply to correct the calculation and limit it within the bounds of Section 194 to 12 months, because in the manner in which it was set out in the initial judgment, it would have been something like 13, 14, or possibly a longer period. So all it was done, I didn't see how an appeal court should be saddled with a calculation error. And that is the reason why. So the context for the variation is explained in that decision. And as matter stands, I'm not so sure whether I should speak on it, because that matter is the subject of an appeal before the LAC.
The only question I had, Advocate Ford, was which rule you applied, because it's not clear from your judgment.
Which rule did I apply to vary the judgment?
That's correct. You handed down a judgment and then you subsequently varied it, but you don't reference any rule.
Yeah, Commissioner, I don't have the judgment in front of me, but the variation would be done within the context in which the court allows for variation of rules and orders. I can't remember the specific rule now in terms of the new rules.
No, sorry, Chief Justice. I'm not sure if Commissioner Pillay is finished, but I would really like to make a follow-up on this point.
Thank you, Chief Justice Ampere.
Please do.
No, you see, the problem, Advocate Ford, is that I've got this judgment here. It doesn't refer to any rule. What seems to have happened is very simple. I'm not sure why you are not directly confronting it.
Yes.
You made a mistake in the amount you mentioned in your judgment. Then leave to appeal comes. Then you realize that you've made a mistake. Instead of either postponing the leave to appeal and asking for a rescission of some sort, you then decided to combine your leave to appeal with a rescission. And that's why you're being asked, how can you do that when you have to deal with a leave to appeal, which presupposes that you are functus officio? And what you do to avoid the problem of functus is that you just combine a rescission with a leave to appeal. That seems to be irregular. That's what is being asked.
Yeah, Commissioner, my view is simply that the application before me was an application for leave to appeal, but prior to that is the having received the application for leave to appeal is the simple realization that there is a calculation error. So if there is a calculation error, and insofar as, and you're quite right to say that there's no specific rule set out in the judgment, but if I am not mistaken, and I don't have all the documents in front of me, there would have been a basis on which I arrived at that decision, and that basis, I speak as far as my recollection can help me, that recollection was to the effect that in circumstances where a judge deals with an application for leave to appeal, he can deal with it in a manner that he sees that he sees fit in order to give effect to the matter being heard without causing any further unnecessary delays to the matter. Because had the process been like you outlined now, for me to indicate to the parties that there's an objective error, they need to bring an application for rescission, etc. Whilst this matter it's a very simple one, there's a calculation error. I'm varying the initial judgment to make allowance for the fact that there was a calculation error, and that error is now corrected. I'm afraid I can't take it any further than that, Commissioner, unless there's another question following from there.
Well, I was going to follow it, but as soon as you say I have nothing further to say, I must shut up.
No, Commissioner, I'm not saying I'm certainly not saying that.
No, I'm not going to pursue it any further. I think you've told me that you've got nothing to add, so that's fine. Thank you.
Any more questions, colleagues? Commissioner Malema, then Commissioner Kane.
Thank you, CJ. Advocate, is there a difference between an arbitration decision and a court judgment? If there is, take me through. What are their effect on those cases?
An arbitration award is not an order of a high court or a superior court. Meaning, when a judgment is handed down, there is a requirement that the parties comply with the judgment. There is a requirement that a high court has the type of jurisdiction which the CCMA and powers which the CCMA, or for this particular instance, the private arbitration institution, don't have.
Now, you are being asked for reportable judgments, not reportable arbitration orders. The whole advocate who knows the difference between arbitration order and judgment, you go and write arbitration orders and want to come and create an impression that you have no idea or none whatsoever. You can't make such a mistake. You knew what you were doing when you were responding to our questionnaire, which is in the main misleading. The intention was to mislead this committee. If the attention was not, if we did not pay attention to detail.
Commissioner Malema, I certainly hear what you're saying, but there's simply no need to mislead by providing information that's clearly observable on the face of it. So I've indicated why I added those two decisions. There was certainly no intention on my part to mislead anybody, and I doubt whether anybody was misled. I doubt it very much.
Commissioner King.
Thank you, CJ. Good afternoon, Mr. Ford.
Good afternoon.
There's been a weakness identified in your application, and we could capture it as saying that your application is thin. I'm giving you an opportunity to rescue one element of it, which relates to your contribution, which you say is in establishing the RSA bar in 2021. My question is, what did you do as a member of the bar prior to that to contribute to the bar? And given that the RSA bar is so new and you're going to now leave it, notwithstanding that you say your biggest contribution to law really has been the establishment of the RSA bar, you intend to leave it in its fledgling days. How do you consider that to be a major contribution to the law?
Commissioner, perhaps let me step back and say my contribution whilst being at the JSA, because that will sort of lead into why and how the RSA bar was established. I, for a number of years, worked at the JSA in the professional committee, and that was where I made a contribution as part of that committee.
I don't see you mentioning that in your application at all. Am I wrong?
No, that is not mentioned in the application, but I thought that's what you asked. But I can, if I may.
Carry on.
Yeah. What transpired was because, and perhaps I was cautious in sharing that information, was that just prior to COVID, or leading up to COVID, we had an AGM And if you attended that AGM, you would recall I was speaking at that AGM, and in particular about the plight suffered by black practitioners at the JSA and the difficulties that they have in having to hold chambers in circumstances where the landscape for them have changed. And then myself, we then recommended a number of interventions in order to ameliorate the situation and to ensure that black practitioners in particular are not castigated or find themselves no longer part of the bar. The response to the proposals I make was very disapproving. In particular, I had proposed that instead of dedicated buildings where members ought to practice from, that they should be allowed to practice from other suitable buildings. And in addition thereto, I proposed that the manner and style in which chambers are held must be revisited and set out in granular detail how that process could work and what ought to be done. That proposal was voted against at the AGM. Pursuant thereto, myself and Ishmael Semenya met and we discussed what next to do. Firstly, to ensure that those who have found themselves at the short end of the stick, so to speak, could be considered. And that is then where the idea of the South African Bar Association was born. And what it sought to do is to achieve exactly the things that we punted for, but didn't get within the JSA structures. To say that, to set up an institution where you reduce subscriptions, where you allow the flexibility of holding chambers in a manner that is still consistent with the practice of an advocate, but not in high-rise or buildings dedicated to the practice as specified. We also then looked at the transformation initiatives in making it easier for people to practice, as well as making it easier for female practitioners entering into the profession. And since 2021, we then brought our application, established the RSA bar, applied to the LPC to be accredited. We've been accredited to conduct pupillage training and making it easier for people to give expression to their practice of law in the preferred style and manner without being forced to quit the profession as a result. So that in a nutshell is the background giving rise to the RSA bar. Now, no organization ought to or should be based on one person's individual participation, in the sense that it would be foolhardy to establish any organization, political or otherwise, that's based on an individual, because tomorrow I die. And one would want to have an organization, and I want to believe the organization that we have is one where there will be continuity. And that continuity is, I suppose, what every organization requires. So whilst your concern, Commissioner Kane, might appear valid, I think we have made the necessary contingency plans to ensure that there will be continuity in the RSA bar. I hope that answers your question, Commissioner.
Thank you, Chief Justice.
Any other questions, colleagues? No. Thank you very much for making yourself available, Mr. Ford. This is the end of your interview. You're excused.
Thank you, Chief Justice.